Good morning, everyone, both in the room and online, and welcome back. Welcome to our main session number 1, when we will be discussing data protection in a changing world and what lies ahead with a panel of distinguished speakers. So my name is Anna Buchta. I'm the head of Policy and Consultation Unit at the European Data Protection Supervisor's Office. And I would like to present to you our panelists. First, to my left, John Edwards, who is the UK Information Commissioner since early 2022. So the Independent Data Protection Authority in the United Kingdom. And previously, he had been the Privacy Commissioner for New Zealand. Then Mrs. Irena Mozova, who is Deputy Director General for the Director General for Justice and Consumers, DG Just, of the European Commission, responsible for international dimensions of justice, rule of law, and equality policies. Alberto Di Felice is Policy and Legal Counsel at Digital Europe, a trade association representing the digital industries in the EU. And Mrs. Marina Kaljurand is first Vice Chair of the Committee on Civil Liberties, Justice and Home Affairs, so the LIBE Committee of the European Parliament. Last but not least, we welcome Mr. Michał Gramatyka, who is Secretary of State at the Ministry for Digital Affairs in Poland and who is here on behalf of the Polish Presidency of the Council. So, as we have heard earlier today, we are at the dawn of new mandates at the Council of Europe, also at the European Commission. The new Polish presidency has just begun. We are seeing new openings also elsewhere in the world with the recent inauguration of the second Trump presidency. So new winds are blowing. Specifically in the EU, with the appointment of the Commission following the parliamentary elections, we are already seeing certain shifts in emphasis when it comes to data protection and digital regulations in general. So pressure is rising to ensure that the implementation of data protection law remains in line with the other objectives: digital transformation, needs for law enforcement, and other commercial interests. There are also some pending unfinished files, unfinished business from the previous co-legislature, such as the e-privacy regulation, the proposal on combating child sexual abuse material online. And at the same time, we are hearing increasing calls for simplification of the EU digital regulatory landscape and even deregulation. So one can say that traditional approaches are being put to a test and are maybe not sufficient. With this panel, I would like to explore what comes next in the next weeks, months, years, and what can we expect as the first challenges and priorities to be tackled by the respective institutions and bodies. So I would like to start with the European Commission. We are still waiting, of course, to see the official Commission work program for this year, but we have already read the political guidelines of the President. We have seen the mission letters, including the one for Commissioner for Justice McGrath. What can you share with the audience regarding the Commission's focus and priorities?
Thank you very much, Anna. And let me start by thanking you all for being here and being so committed as a data protection community inside of the Europe, but also beyond, because this is one of the features which are somehow putting a new framework for our policies. But let me also say that, as Anna rightly pointed out, so we are at the crucial moment of the new college. This is a new mandate coming up. But there is something which stays, and this is the strong commitment to support the innovation while at the same time dedicating to the preservation of the European values and fundamental rights. What is new in this mandate, and you have already mentioned it in your opening in a way, so it is the fact that we are much more committed to cut the red tape and also eliminate the unnecessary administrative burden. And you rightly pointed out that, yes, indeed, we are not yet there in terms of the work program, but the political guidelines, they are giving us a rather clear framework. First and foremost, the European Data Union strategy, which has been already announced and which should aim at simplified, clear, coherent legal framework for businesses and administrations to share data seamlessly and at scale, while respecting high privacy and security standards. Now, we, as a Commission, we will recommend a non-binding model terms for the data sharing and implementing the rules of the Data Act to contribute to the same. So this is the first thing that I can already share with you. Now, in addition, the European legal data space will make available vast amount of judicial data, including, and this is a novelty, for training artificial intelligence to achieve the aim of the European Data Union strategy. Now, let me move to the very key component of our future policies, which is, of course, the GDPR. As you may recall, so last summer we published the second report on GDPR. And this was also a very good opportunity to reflect on the past, but also already to look a little bit on the future. And in preparing this report, we saw the views of the very large range of the actors. And I believe that many of you are maybe sitting in this room or watching this conference, because we have been receiving inputs from the businesses, large and small, and across all the industries, but also from civil society, national data protection authorities, member states, but also individuals. And the clear message we received was that the GDPR is still and continues to deliver effectively. And what is even more important, that there is the balance is preserved. It means that the individuals, they feel protected by GDPR, and they can also actively exercise their rights. At the same time, the data controllers and processors, they value the GDPR's risk-based technology and rather neutral approach. But also in our report, so we have identified that still more can be done to realize the full potential of the GDPR. And we have been recommending a number of the follow-up actions. And one of them, which I believe will be very welcome, is to need to further support businesses' compliance efforts, and especially the small and medium enterprises. And we can even look into how we can support the mid-caps. It is equally important to ensure consistent interpretation and the enforcement of the GDPR. Because too often the data protection authorities, they adopt rather divergent interpretation on the fundamental data protection concepts. And this can, and as a consequence, create legal uncertainty for the individuals and also for the businesses. And this can lead into the increasing costs and even hindering the free flow data in the union. So this issue, and let me also make it clear, so was clearly expelled and identified in the Draghi report as one element which may discourage innovation and investment in Europe. And once again, I'm coming back to the opening of my intervention, because this is the focus of the current term in order to preserve the competitiveness of the European Union in the worldwide framework. So it's really crucial that the national data protection authorities and also EPBB, they solve these divergences in the interpretation as a priority. So for us, it is absolutely crucial. Now, let me also say that come to the foundation of the digital rulebook and cross-regulatory cooperation, because in the recent years, so we have seen that GDPR provides a trusted foundation on which the European has built the key digital policies. And here I can speak about the regulation of platforms or also artificial intelligence to create a single market for data. And these initiatives, of course, they complement the GDPR, all specify so how it should be applied in the specific areas. And the aim is, of course, to allow, again, the businesses and individuals to harness on both sides the benefits of the digital transition, but at the same time, so keep the balance when fully respecting the fundamental rights. And just to give you some examples, for example, the European health data space, it is one of the major achievements at the European level, soon to be concluded, hopefully by the Council. It will foster an exchange of the health data across the European Union to improve the healthcare. It will also enable the reuse of the data under, of course, very strict conditions and robust privacy safeguards for the public interest. And it can help to advance the scientific research and foster, again, the innovation. Now, the EIDAS revised regulation is another good example of enabling individuals' control over their personal data, because the regulation provides for the measures to share only necessary data where individuals are requested to identify or verify their identity by electronic means. And you know that we have very good projects already putting forward, like a digital wallets, but many others. The sharing is taking place by applying state-of-the-art security measures, and the use of those eID wallets is essential for the uptake of electronic services and cross-border exchanges between citizens, but also public authorities. Another good example of the really groundbreaking European legislation is the Artificial Intelligence Act that businesses will benefit from, and provides for, again, so one set of the rules to access but also operate on the European Union market. And consumers at the same time so will have the guarantee that artificial intelligence developed and use it in the European Union corporate safeguard protecting the fundamental rights. You have mentioned the mission letter, and I will almost conclude, of Commissioner McGrath, that we are currently working also on the Digital Fairness Act. Comprehensive public consultation will be launched in the spring in order to put it right in the context. And all stakeholders, including those, again, so present in this plenary and online, so will be able to contribute, because certain topics like personalizing practices are of particular interest for the community, and I really would like to engage you to fully engage in this consultation. And of course, now new digital regulation will involve questions falling within the domain of the several regulators, and we must break the silos to establish a good cooperation, efficient cooperation across the different regulatory fields to address this growing digital demand, and also to enforce it coherently and effectively. So the cross-regulatory cooperation, for me, it is absolutely essential, and let me also welcome this event because it is contributing to this effect as well. Thank you.
Thank you very much for this rich overview. So data union strategy, digital fairness, innovation, cross-regulatory cooperation, and consistency. I think the tone has been set. So let me move now to the Polish presidency of the Council. Poland has taken over at a pivotal moment for the Union and probably for the world. What are the key priorities of the presidency that our audience should be aware of? And what do you expect to achieve in the next 6 months in this space?
Thank you, Anna, for this introduction. Good morning, everyone. Thank you very much for giving me an opportunity to speak at today's panel on the future of data protection in the context of functioning of the European Union institutions. The Polish presidency of United Europe, which began on 1st January, will be crucial in shaping Europe's digital policy further. We aim not only to support existing regulations, but also to initiate actions that strengthen the coherence and effectiveness of EU policies in the area of digitalization and personal data protection. Let me please outline some priorities of the Polish presidency in the digital area, in the digital sphere. We'll focus on 4 areas. First one is cybersecurity. And what is most important for cybersecurity is elimination the silo effect in digital policies and building synergies across various digital areas. The Polish presidency will try to boost the EU's resilience by developing a comprehensive and horizontal approach to cybersecurity. Our goal is one common model for responding to large-scale incidents and a single reporting system for all incidents. We also need to update and strengthen the EU's crisis coordination framework in cyberspace, also known as Cyber Blueprint, and improve cooperation between the civilian and military areas. Another thing we want to do is initiate discussions on best practices in EU member states for investing in cybersecurity. Next priority is, of course, artificial intelligence, AI. As for AI, we aim to create proper conditions for the development of this area. On the one hand, we support the development of such applications, but on the other hand, we must ensure their safety. The EU needs a common vision for the development of this technology. Therefore, we will actively participate in preparations for the new AI Apply strategy. I repeat, the EU needs a common vision that must be underlined, especially today, 2 or 3 days after presenting the DeepSeek, the Chinese AI model, which is better, cheaper, and which needs not as much modern chips as the previous models, and which is free, not commercial, and which is open-coded. We plan to actively participate in the creation of AI factories in the EU. They will improve access to high-performance computing resources and establish a robust data infrastructure. From Poland's perspective, another area of our presidency, I mean external digital relations, are also crucial. The digital transformation brings added value both for EU member states and for candidate countries. Therefore, we want to support them on their path to full integration with the EU digital policy. We aim to strengthen cooperation among various international organizations in digital areas. For me, as a minister responsible for the telecommunications in Poland, cooperation with one of the oldest regulation organizations, International Telecommunication Union, they first regulated the telegraph in the 19th century, as far as I remember. As far as I don't remember, in fact. That cooperation with ITU is particularly important. So last but not least, currently European business must cope with a vast number of digital regulations. We want to support them by reducing administrative burdens. As the presidency will seek consistency between the solutions contained in the various pieces of legislation. We'll also promote systematic reviews of implementation progress and the exchange of best practices. Once again, thank you for having me here. Thank you for inviting me. I wish you a fruitful debate and inspiring discussions during today's event. Thank you very much.
Thank you. And of course, we will continue this discussion because you're not leaving us yet. But before we do that, maybe let's move to the other co-legislator. So the European Parliament, which is not really new anymore, but is only starting its substantive work, which is picking up speed. So which pending files or new files, what do you expect? What are the current topics focus on your work, and what do you expect in the coming months?
Thank you, Anna. And like previous speakers, I'd also like to thank EDPS for having this event today. Mr. Vyavorowski, your office has been always very supportive of data protection. It has been a real pleasure to cooperate with you, with your colleagues, with your office, and happy to give some insight after the other EU institutions have spoken already. I'm new in politics. It is my second term in the European Parliament. It is my second term in the LIBE committee. And this term, I have the honor and privilege of being the first vice chair of the LIBE committee. I come from Estonia, yeah? Which means that you always do digital topics when you come from Estonia and you are in whatever institution. So one of the first things I was doing during my first term was terrorist content online. And one of the last things I was doing during my last term was digital identity. But also like to add that my past is I was very much in the government. I was also representing other multi-stakeholders, and my love for digital topics started in 2007, when I was Estonian ambassador to Russia during the cyber attacks on Estonia. So since then, cyber has accompanied my life in different forms, and I also had the privilege of advising UN Secretary General on digital cooperation. But here, I can speak only on behalf of LIBE. So maybe later, during the discussion, there will be also a chance to reflect more widely on other topics that are also close to my heart. Yes, as you rightly mentioned, we are entering a new phase of EU institutions and of Parliament. The Parliament is still settling down. And if you look at the composition of the Parliament, it's very different from the one that we had during the previous term. And the digital topics, well, how to put it politely, can't say that they are very high on the political agenda in the European Parliament, and can't say that there are too many members of the European Parliament who really do care or who are really interested in digital topics. And especially reflecting on the digital ID, how difficult it was to explain that we need in today's e-services world one form of digital identification. Because for many members of the Parliament, it meant that we will all have numbers in our hands and governments will start spying on us immediately from the first second. And what makes it also difficult in the Parliament is that the knowledge is so uneven. There are some countries who are really good, who have experienced, and there are some members of the Parliament and some countries who are just discussing it theoretically as an academic exercise. And to bring all the positions together, not easy. So if I look at the coming term, I would say that we have some leftovers, not in the bad sense of the word, from the previous term. And of course, there will be new challenges. Very happy to listen to Commission and Presidency, can say that share absolutely your commitment and your endeavors, and happy to have Poland as a presidency during this term of the presidencies. So maybe two aspects that the LIBE committee is dealing most are the data protection from all aspects of data protection, international transfers, cooperation, access to data by different authorities for different purposes, but also artificial intelligence. And trust me, all the committees in the European Parliament, they're fighting for their role, for their files, for their positions, so you can't overstep the lines that are distributed among different committees. So LIBE has also, we have to keep to the topics that we have under the regulation of the Parliament. Can't avoid mentioning GDPR, which was also mentioned by both previous speakers, and the procedural harmonization. The position of the European Parliament is very straightforward. Like other institutions also mentioned, we focus on improving the enforcement of the GDPR rules in cross-border cases while empowering individuals and non-governmental organizations that represent them in the proceedings before the national authorities. Parliament has started its work on this file. There have been a couple of meetings already, but we really do hope to conclude the work on this file during the Polish presidency, and listening to you, I think that we can be rather optimistic about that. Another regulation which comes from the previous term is the e-privacy regulation, which is a special legislative proposal that my very dear colleague Birgit Sippel from my political family is dealing with. And the proposal is supposed to turn the e-privacy directive from 2002 into regulation. But here I have to say that we are stuck from 2022. Parliament is ready to negotiate. So here I think I'm looking more towards Commission and Presidency. What are going to be your views on this topic during the coming legislature period? There has also been a high-level group on access to data. And the European Parliament and LIBE particularly was invited to attend the meetings, but we declined. We did not participate in the work because we see that as co-legislators and its prerogatives to express its position only once agreed by majority. So we are not turning our back, but we will step in when we find that the time is right and appropriate. And that is why none of the LIBE members were involved in the discussions. Artificial intelligence, another priority. In October last year, there was established a joint working group where LIBE committee is cooperating with IMCO committee, and negotiations have started and the work is taking place. Adequacy and international transfers. I was also personally involved in the work on these topics, and they are difficult. So I'll start with the EU-UK data transfer. I think that many of you remember it was back in 2021 when LIBE committee expressed a number of concerns regarding the UK adequacy findings, both under the GDPR and under the Law Enforcement Directive. And perhaps, as you all know, the adequacy decision will expire automatically this year, in some months, on the 27th of June. So we really in the Parliament look forward to see how Commission is dealing with the matter, and we will be following this topic and we will be participating in the negotiations, and we will be monitoring like we have been also during previous times, previous mandate. And as an example was our contribution to last year's inquiry by the UK House of Lords as an example of our past involvement in this regard. And now coming to the United States. I was Estonian ambassador to Washington during Snowden revelations. And trust me, that was the lowest point in trust between EU and United States. As a politician, I can say maybe more things than I had the right to say as an ambassador or as a member of the government. But on the digital topics and tech giants and platforms, I see that we are going to have really, really challenging and difficult times when cooperating with the United States. United States is our ally. We have the same understanding. We are natural allies. But it doesn't mean that we agree on all the topics. I don't know whether you had the chance of follow the discussion at the plenary that took place last week in Strasbourg on DSA, Digital Services Act, on content moderation, on the behavior of tech giants. It was an open discussion, it was frank discussion. I think Commissioner had a very good statement. Commissioner was very focused, very committed, and I think the most important thing is that we will keep to our principles, we will keep to our values, and we will not give up well, frightened or when being blackmailed. That's one of the topics. Personally, I'm really worried about the fact that Meta and others are stopping or have stopped already fact-changing. But when I followed the discussions in the European Parliament, I said that this Parliament is different from the previous one. And unfortunately, I see that there are members of the Parliament who echo the same, that fact-finding is not needed, it's suppression of freedom of speech. So on this topic, we will have really, really challenging times. And as to the data, my final remark, and as to the data transfer between EU and United States, well, again, I think that you all read one of the first decisions of President Trump when he wanted to oust 3 members of National Privacy Watchdog, which is the key part of Europeans' privacy protection. So according to the White House, 3 democratic selected members of the Privacy and Civil Liberties Oversight Board were asked to resign or would be fired in coming days. It was reported by the New York Times, it was confirmed by Politico, but of course these are again media outlets. That's something where I think from the Parliament perspective, we need to know what will be the next steps by the Commission, what will be the next steps by the Presidency, because this oversight board was tasked with overseeing US surveillance practices and addressing complaints from Europeans about any misuse of their data. So these steps, even if the 3 positions will be filled in, they just leave kind of weird feeling, or at least they show not exactly the steps that we expect from our close allies and partners. Having said that, looking very much forward to the discussion and looking very much forward to the coming mandate of the European Parliament. Thank you.
Thank you so much. Thank you so much for your very frank remarks. I am sure there are many things that other panelists would want to react to, but let's leave that for just in a bit, and let's give the others a chance to speak. So, John, well, not only the transfers, of course, and all these past discussions have been mentioned already many times, but what I'm taking away from several of the interventions is the importance of international cooperation. Maybe more so today in those changing, uncertain times than ever before. And also it seems to me that the topics, the challenges that we are dealing with on both sides of the channel are not exactly completely different. So what is your take on those key challenges and opportunities that data protection and digital regulations will face?
Thank you. Thank you, Anna. Thank you, Wojciech, for hosting this event, and happy Data Protection Day to everyone. Yesterday morning, I was at St. Pancras Station in London waiting to board the Eurostar, and I paused at the bookstore and I picked up a copy of The Economist and I flipped it open, and there was a story about this company called DeepSeek, which had a new technology approach to training large language models. I thought, wow, that's interesting. They can do that for $6 million. Within a couple of hours, the stock markets in the US had opened and billions of dollars was being wiped off traditional tech firms, including NVIDIA and others. By the end of the day, I was at a dinner where we had a keynote address from an academic talking about the challenges of regulating DeepSeek's model in China for data protection authorities in Europe. So, of course, I've woken up this morning, like you, an expert in the economics of chip manufacture and supply. And I mean, I think the example just shows how fast our business, our industry, our concerns are moving. And I'm going to risk embarrassing myself here, but can I just get an indication in the room of how many of you had heard of DeepSeek this time last week? Well, thank you. I'm not the only one. it is just extraordinary how rapidly these disruptive technologies can change our agendas. Speaking of agendas, in the UK, we, like you, have had a kind of Draghi moment. Just before Christmas, the Prime Minister wrote to all regulators and said, we need to do growth. We need each regulator to set out 5 plans that they have for promoting growth in our country. And like my colleagues, I had to reply to that. And I want to just give you the headings. We actually did 7 because we we suck up a bit. But the 7 items that we said that we would focus on to promote growth as a DPA were: first, giving business regulatory certainty on AI. Second, like my colleague Marina in the Commission, cutting costs for small and medium-sized enterprises. Third, enabling more innovation through our regulatory sandbox and innovation advice services. 4, unlocking privacy-preserving online advertising. 5, making it quicker and easier to transfer data internationally. 6, cutting the cost of engaging with multiple regulators. And I think what we've heard from the presentations this morning is that there's quite an alignment in these. We didn't discuss, we didn't consult, but we have the similar preoccupations and similar imperatives. We simply cannot ignore the changing geopolitical situation, the changes in the US, and the imperatives from political masters as to promoting growth and innovation. But as a DPA, we have limited resources, so we must be targeted with how we allocate those. Like DPAs in Europe, the ICO has a certain amount of demand-driven work that we must prioritize and allocate. But within that, there is some discretionary capacity. So what we've done at the ICO is to decide that we will set 3 causes. So to the extent that we have discretionary capacity, we will choose not to distribute our resources evenly across the whole economy, but we will decide that the important things are AI and biometrics. We will focus on online tracking and advertising and children's privacy. And so that's where we are going to focus in the coming year or 2. In December last year, just to illustrate how we have advanced some of these points, we set out new policy positions in collaboration with experts on generative AI. And I know EDPB has also issued guidance, and I'm pleased to say that there is quite a significant degree of alignment in those. We've recently published an online tracking strategy. We're aiming high, and we're looking at challenging compliance for the 1,000 top websites in the UK. And our continued work on children's data includes data lives research, and we will be looking at more at recommender systems in platforms which are serving content to children. And this is going to be a really significant focus for us. Globally, as Anna alluded to, it's really important to collaborate and cooperate. We are members of a number of networks, including the G7, the global CBPR, and we have alliances with APA and other privacy networks to ensure that we can coordinate. But I do want to just briefly address another preoccupation for us this year, and that is the Data Use and Access Bill. A couple of years ago, I appeared in front of the Libe Committee to talk about the previous government's reform proposal, and there were some quite challenging questions and some questions about the extent to which the UK could depart from the GDPR while still maintaining an adequate level of protection for Europeans' data within the UK. The new government has listened to the European Commission, has introduced a bill which has none of the aspects which were of concern to the previous Parliament. And I'm really hopeful that we will be able to have an ongoing conversation and dialogue about how we are able to achieve the highest levels of privacy protection with a slightly customized approach to the GDPR. I think I can confidently say that when the Libe Committee, when the Parliament, when the Commission examines the UK legal framework, it will find it is more similar to the GDPR than any other law that has received adequacy status. So I do urge all parties to take note of what Marina has described as the cliff edge of 30 June, and not to let that adequacy lapse. It's really important for you. It's really important for us. It's of huge economic value. And sorry, that's my bell ringing. I set for 7 minutes, so I better stop because my egg is cooked.
Thank you, John, and thank you for taking that particular bull by its horns, I would say, on adequacy and the expectations there. So finally, you've mentioned the Draghi report, we had the Letta report, we have heard the commitments to innovation, simplification, and the plans for data union strategy, the competitiveness compass. So it seems to me like the industry must be quite pleased that the policymakers are finally listening to you. Is this the case? And what, in your view, should be the priorities for this new mandate?
Thanks a lot, Anna. Happy Data Protection Day, everyone. You're talking like it's in the bank. I'm not sure it's in the bank yet. There's signs. But I was thinking just this morning, this is a data protection conference. I feel like we're still very much in the bubble, even in this discussion. It's very slow, this idea that we should simplify the regulatory environment. We had, it's a great event, but you look at the opening panel, we had 2 academics. Now I'm the first industry representative on a panel. You're going to have a couple more in the afternoon from companies. But industry is sort of distant from these discussions. We're still having relatively academic discussions about the confines of data protection and the relationship with AI, et cetera. In the meantime, businesses are relatively remote from what's going on. So we like to talk about the tsunami of regulation that we've seen in the past 5 years. You're all familiar with the problem. You've described it. So it used to be that, and I'm talking specifically about the regulation of data processing, personal, non-personal. It used to be that we could just, live with the GDPR, which was a headache in and of itself. GDPR, as mentioned consistently, has heavy regulatory burden for any company in all surveys, including our own surveys of our broad membership of both large corporate members and NTAs, 45,000 of them, of smaller companies represented by national trade associations. So that was hard enough already. We know that it's hard on public authorities as well. I don't know how many projects by hospitals and healthcare authorities weren't ultimately pursued because people didn't know what legal basis could apply to their project. And now all of a sudden, we have an amount of digital regulation that's unprecedented. A lot of the new laws you've mentioned, so there's clearly the AI Act, which gets the privacy community very excited, but then we have the rest of the data strategy. So we have the Data Governance Act, we have the Data Act, we have regulation of data sharing in the financial sector. 2 proposals, we have the European health data space. So there's a lot. And actually, as businesses so far, what's happened, this is not really a tsunami. This is an underwater earthquake that's happened. And as businesses, we're on the coastline, and we felt some sort of earthquake. We haven't seen actually what was happening there underwater. But all of a sudden, we start to see a wave that's coming our way. And we as businesses, it's a diverse bunch. I think it's fair to say, I hope they won't judge me negatively, but particularly European businesses, we talk about a lot of the big platforms and big challenges around big tech. But if you think about the vast majority of European businesses, they are particularly remote from our discussions. They don't have a lot of lobbyists here in Brussels who are paying attention to what's coming out of Brussels. So most of them are either not paying attention, and we try to do the best that we can as a trade association to help them. And some of them even have the very negative attitude of saying, well, I'm a European business. I live by European values. Of course, I'm ready to comply. Whatever comes my way, I'm just going to comply. And now all of a sudden, because the environment has been so bad, so we're on the coast pretty depleted. Letta, Draghi tell us that past 20 years, we've lost 30% of GDP compared to the US. We've lost competitiveness. compared to the US, not to mention China. And we know that most of that has been because we haven't been able to deploy digital and use digital to improve our productivity. So we're depleted, and we see this wave coming our way. And all of a sudden, these businesses start saying, I think I miscalculated my preparedness level for what's coming. I don't want to be, engulfed by this wave. And this is the you called it, simplification to regulatory agenda that we see that must be coming. There's a big wave of simplification, particularly in sustainability reporting. There's talk with fewer details about how we could simplify digital regulation. Certainly, data union strategy now is a big way to do that. But there is also quite a lot of other things that's not purely regulatory in nature that needs to happen with the next commission. There's two other pillars in addition to cutting burden. There's one piece that's about completing the single market. We still have challenges that are incredible for European businesses to scale across Europe. We still have 27 markets, and businesses move out to the U.S. Predominantly for funding reasons. We don't have a Wall Street. We need to complete the capital markets union. And then the third pillar is that we need to absolutely think about how we spend our public money and investment. We have a multi-annual financial framework in Europe, which is less than the budget of the US federal government any given year. We still have a lot of pockets of funding in the member states, a lot of national procurement. We don't think big in terms of how we scale our public spending. And this is something that we absolutely need to do. Whether we can spend less like the Chinese, which is actually encouraging for Europe, because probably it means that we don't need as many types of investments as we thought, but we still need to invest quite a lot. So we need to pool our resources and be doing those things. And we do need to, one thing that we can certainly do here in Brussels is to simplify regulation quite a lot.
Thank you. That's not an ambitious agenda or a tall order at all. Thank you also for broadening the picture to mention other challenges. So not everything, I believe, is the fault or can be solved by regulation in the digital sphere. But of course, challenges are clear. I am sure that there will be reactions to each other presentations, but you will have an opportunity to do so a bit later. I still would like to ask you some specific questions, in particular about this one possible way to make progress towards coherence and consistency of implementing the regulation which we already have, and waiting for possible further steps towards simplification. And this is the cross-regulatory cooperation. And I think that the Polish presidency also has a cross-regulatory approach towards digitalization and its challenges. So, Minister Gramatyka, could you tell us more about that?
Thank you for your question. I'm a little, I'm afraid a little bit about Alberto's speech, because every underwater earthquake caused tsunami. So, but, well, the experience of Polish Ministry of Digital Affairs is quite unique to my knowledge. This is a rare case in United Europe where the digital portfolio includes not only telecommunication or new technologies, but also data protection and cybersecurity. In particular, data protection is often within the remit of justice and home affairs ministries in other member states. I think this corresponds to the reality on the ground. The most pressing issues with regards to data protection are those that concern the use of new technologies and the processing of data by providers of digital services. This is also evident in the choice of the very interesting topics for today's event. The structure of our ministry and our broad understanding of the meaning of digital portfolio allows us to maintain a very horizontal view. For what concerns data protection policies, it allows us to think the digital dimension very early in the policy making and implementation processes. Many of you here in the audience work in various governmental and international institutions. You will probably agree with me that it is much easier and more effective to talk to a colleague down the corridor than to consult another ministry. As for a cross-regulatory approach and breaking down silos, the integration of various digital regulations is one of the greatest challenges facing the European Union. We have had an intense couple of years of creating new digital rules. We now need to put all that energy into implementation, but we need to do it in a smart way. So to conclude, personal data protection and the development of digitalization are two sides of the same coin. The Polish presidency will work to create a cohesive regulatory ecosystems that foster innovation while ensuring the highest data protection standards. And cooperation will be some kind of cornerstone of our actions, both within the European Union and international level. We believe that together we can meet the challenges of the future. Thank you.
Thank you very much. And in terms of this cooperation, both internationally and cross-regulatory cooperation at national level, this is very much on our mind. Of course, you have heard the DPS has just put out a concept note on that. The DPB has issued a paper. And John, I believe you have quite some first-hand experience with that. Could you share your insights briefly?
Thank you, Anna. Yes, and I think that we all in the international community recognize the vital importance of cooperation and collaboration. We're dealing with companies that are bigger than any have been seen in history. They are in every country. So we need to have coordinated approaches. There are a number of fora for that we participate actively in. There's the Global Privacy Assembly, which is a very warm collective of data protection authorities. The G7, the Global CBPR Forum. The ICO has memoranda of understanding for cooperation with 5 European data protection authorities: Ireland, the EDPS, Malta, the Netherlands, Germany, of course, all of which are really important and bind us together. But just having those agreements on their own is not enough. We have to actually talk less about cooperation and do more, particularly in the enforcement sphere, I think. And in that zone, we at the ICO have a history of collaboration with Australia in regulating and enforcing against Clearview AI. In the last year, we've been working closely and jointly with the Office of the Privacy Commissioner in Canada over breaches by the genetic testing company 23andMe. And you will see the fruit of that coming soon. It's really important that we collectively agree on high standards of practice. And I was really pleased to sponsor the joint statement on age assurance. So this is an issue, again, which is going to affect us all. And so as DPAs, it's really important that we have a common approach to businesses which are operating in all our jurisdictions. So that international cooperation is so important. The adequacy network is, I think, a really important network for sharing values and experiences. It joins together. The adequate countries constitute a population of some 450 million people and 40 billion in GDP. So combined with Europe, that's an incredible force for good. I think there's more potential there for realizing the benefits of that adequacy grouping. But in addition to international cooperation, we increasingly need domestic cooperation. I think we've heard of that today. And that's why we in the UK have the Digital Regulators Cooperation Forum, which is an entity comprised of the Communications Regulator, Ofcom, the ICO, the Financial Conduct Authority, and the Competition and Markets Authority, because increasingly we are seeing interventions which touch upon two or more of these domains. In AI, we're talking about the things that cut across all four domains. So it's important that we're able to present a united front to industry and to get our stories straight, to coordinate, to understand the trade-offs between competition and data protection. With Ofcom, we're dealing every day with they have responsibility for an online safety law, which is so close to data protection that we've got to ensure that we are really in lockstep. The data that drives the content that's delivered is my domain. The content which appears on a young person's phone is their domain. So we can't be letting any light between those two. And I think that concept of the Digital Regulators Cooperation Forum also has more potential to be realized. And it is being picked up internationally. We're seeing others in Ireland and other jurisdictions, Canada, Australia, also bring together those domestic regulators. And I think I'm detecting agitation, so I should stop.
Thank you very much. I really didn't mean to interrupt, but indeed we should try and stick to the time and give the others a chance to speak as well. Alberto, I guess this idea of implementing a dialogue or a structured dialogue, cross-regulatory cooperation between different enforcers would already be a positive step from your perspective. And is there any other idea, initiative that you think could or should be implemented as a priority in this term?
Right. So I think cooperation is good, but I think it's gotten to a point where it's gotten incredibly more complex than is manageable. So it used to be that cooperation needed to be between privacy authorities, competition authorities, audiovisual regulators. Right now in Europe, we're facing a situation where a company that has data processing operations on any given market will have, under current conditions, data protection authorities, an authority responsible for the AI Act, which may well not be a data protection authority. They may have interactions with data from the public sector. There will be authorities responsible in each member state for implementation of the Data Governance Act. They will be manufacturers of connected devices, most likely, either as the main product or as an appendix to their main service. And they will have authorities responsible for implementation of the Data Act. They may also serve the financial sector. They may have to interface with financial authorities. And each of these, just for the Data Act, we're facing a situation where we could have at least four different authorities responsible for the Data Act in each member state. And for Germany, that may even be for each state, as is usually the case. So if you put all those people together, you're talking about a community of 200 people just in Europe. There's literally no way that collaboration in and of itself will achieve great harmony. I mean, look at what's happening now, even just with the GDPR procedural regulation. It's a regulation where we have, hopes that there will be less conflictual types of choices and decisions coming out of data protection authorities, because we know that there's been a level of disagreement as to how to interpret a lot of the GDPR. And we hope that we're not going to make it worse and more conflictual. But that's got to be a problem. So we cannot just count on collaboration and people getting together in a room and having conferences every year. We need to bring both the level of the rules down. So we do need that agenda of simplification. So far, it's been terrible. The quality of the regulation that's come out of Europe has been pitiful. I have this exercise every now and then of going back and checking the AI Act and Data Act in the official journal. And there's articles of the AI Act and the Data Act that stretch 2.5 pages worth of the official journal of the EU. There's paragraphs of those articles that stretch 17 lines that say that there's a first rule, then there's 3 exceptions to the rule. There's a sub-exception to the second exception, and then in the end, the Commission anyway has the power to specify everything over implementing acts. It's becoming a bit too much. We need to bring this complexity down. We cannot just be happy to say that everything that we're doing is complementary to the GDPR, or in legal terms is without prejudice to the GDPR, which simply means that we're not happy to figure out exactly what's happening. We're going to leave it to the regulators and the courts to figure out, because GDPR still applies, the other rule still applies. We'll see what happens in court. This is going to be very costly for everyone. So we need to bring that down. Data union strategy is a perfect way to do that. And we could do some very simple things, some simple things that talk about adequacy. Our UK friends have been trying to do with their reforms of GDPR. We're still having discussions about how can we use pseudonymization. What is anonymization actually? We're still awaiting guidelines and concepts around that. So this is a chance for us to start using new rules as an enabling type of regulatory environment. The discussion that we always have around the legal bases. We're just having legal basis discussions about how to train AI models, for example. We can't say decisively that legitimate interest can be a good legal basis to do this. We're still at caveats. I'm still trying to recover the funny anecdote, but I'm still trying to recover from guidelines from the EDPB. From first draft was 2019, and final guidelines 2020 about video devices. So we all think about video surveillance, et cetera, but this was about an example of use of legitimate interest. In the guidelines, to this day, you can go to the EDPB website and check it out for yourselves. They say that if you own a jewelry shop, you cannot count on legitimate interest to install security cameras in your shop because there could be, theft and burglary. No, you need to provide evidence that your shop is in a particularly bad neighborhood, that where shops in the area have suffered theft in the past, or you have had robberies in the past, and only then are you justified to install security cameras. Now, I think that's an aberration. We should move away from these interpretations. This is not about changing the GDPR. The GDPR, compared to the other rules that we've seen in the past 5 years, is a masterpiece of the Renaissance coming out of Florence. Okay? But we need to be sensible about what we're interpreting the GDPR as saying. Okay, so we need to be doing a lot of these things, and we also need to think seriously about the number of authorities. There is reduction, and there's this idea of the 28th regime that Letta in particularly pushed. Maybe there's a way to have a 28th regime to give companies the option of possibly going to one regulator as opposed to 200.
Thank you very much. We heard you loud and clear despite the interruption and the noise. So just to reassure everyone, we are not yet over time. Everything is under control. Apologies for that. And thank you for reminding us that also there are high expectations towards not just regulators here and co-legislators, but also the data protection authorities and the EDPB, and the call for coherence and simplification has been heard as well. So, Ms. Mozova, there have been many references to pending files, new challenges, past proposals that are stuck, and maybe we would like to know whether there is a chance they might become unstuck. Can you share any reactions or further insights in that respect with us? Thank you.
Thank you very much. I'm mindful of the time, but also not only the pending files, but many challenges that have been already addressed by the co-members of the panel. So let me just be briefly flying through the several topics that I think they are of the interest. So first of all, I think that Marina already put on the table a rather political vision of the new parliament. I'm very grateful for that. She also mentioned the procedural rights. I think that it is a very important proposal. The ambitions on the co-legislators are slightly different, but as a European Commission, I'm very positive hearing you both, because this is something that is really needed into the assuring the cross-border cooperation, to have a less fragmented framework, to have more certainty in terms of the implementation. I think that also for business community, so it will be absolutely crucial. So here, let me say that the swift and balanced agreement of this important file, so it's our top priority, and we as a Commission will be, or we are already, because we are working for it with both co-legislators here, to support very swift progress on this file. Then I think that Marina also mentioned the e-privacy proposal. So here we are reflecting on the topic. It's not easy. You pointed out at certain difficulties. So let me be prudent here also, as you were, unfortunately. But we have to, of course, take into account the current technological landscape and also the broader European Union legislative framework. Now, Marina also mentioned Adele. So here, so we will, of course, follow up the work of the high-level group. There are several recommendations that we are now looking into that already. And the key recommendation, of course, calls for the legislative action on retention of electronic communication data, and of course also effective access to such data once retained. So this is a file where we will be taking this forward. You have seen the mission letter. So from this perspective, there is a clear mandate as well. We are at the same time very much aware about the importance of facilitating effective access to the retained data for the law enforcement purposes, but also of the challenge of assuring the full compliance with the fundamental rights standards. So I can only assure you that we have already started the work on this file, so addressing the different recommendations and also looking for the future progress here with our colleagues from different services. Now, you mentioned, John, the importance of preservation of the children in the digital sphere. So I should mention here the proposed regulation on combat child sexual abuse material, XAM. Our key principle is to protect the children. This is exactly what you are trying to do in United Kingdom. The prevention for us, the foremost and the first, and this is also the proposed direction regulation focus to combat the child sexual abuse material. So the prevention is the key element. It is very limited, focused on the court actions with only very targeted detention orders. If we are looking at the proposal, is very balanced and really preserving all the necessary safeguards in order to address what is in the heart of this proposal, which means the preservation of the children here. So if the only way of those children to be rescued from the ongoing abuse, which can have a detrimental effect on the whole life cycle, so then we propose to order the detection and also address the private flow of the communication, which is otherwise very difficult to address. So we welcome very much the EDPS and EDPB opinion, which provide suggestions also how to address the topic. We can look into the ways so how to improve the balance and at the same time improve the proposal but preserve the key aspect which is on the core, which means the effective protection of the children. So we will support, of course, the co-legislators. The file is not easy, but at the same time, so the key is the final impact. Let me also react to some previous discussion on the UK adequacy. I can only confirm what John has said. So we have been in touch continuously. We are very much aware of the ticking clock. The bill, we understand, so is addressing many of the concern of the Parliament, but also on the side of the Commission. So we are ready to support our United Kingdom friends in order to do it right. But at the same time, the clock is ticking. So we need to find the best way, so how to progress in order to keep this precious partnership, in order to preserve this very important framework, which is so important also for the businesses. Meaningful of the time will be very brief, but also Marina mentioned the United States current situation, extremely challenging. Of course, we are looking not only on the latest news in terms of the data privacy, but we are looking at the overall context, because we have seen the avalanche of the executive orders. The legislation on which is a key for the data protection framework is in place. Nothing has been repealed. So we are looking at the current situation with the watchdog with a great interest, and we will not be shy to use the instruments that we have in place, so should the situation change dramatically. And my last comment goes maybe probably on the business side. Actually, it was Anna who already started at the opening of this panel, so focusing on the importance of preserving the predictable also framework and environment for the businesses. I believe that the predictability and coherence, no fragmentation. So this is a key for our businesses also to operate in order to improve the competitiveness and the growth in Europe. So this is something that we have the same, I think, understanding of the problem. At the same time, so you can address it in the different ways. You have mentioned already competitive compass. I hope that when the proposal will be on place and you can see what we have done, so you will recognize serious efforts to support the businesses in order to be able to perform out of the best. And also the monetary aspect is very important, budgetary aspect. So we have learned from the next generation when we have been dealing with the most, I would say, the largest challenge in the past history of the COVID. And in order to improve where the European Union stays and support the businesses, to support the growth in the member states. And this is, I believe, something similar that we would like to do also through this new competitiveness compass, and also when looking at the preparation of the next multi-annual financial framework, because these are the tools how we can address under this mandate, which still has a long time to go ahead. So those challenges. And yes, we are looking at the network of the advocacy network as one of the very prominent tool where we can build up on this community of data protection also in the global terms, because the global size of data protection is what also matters from the point of view of the competitiveness of Europe. Thank you.
Thank you very much for all those little bits and pieces of information and for your reactions to the other points. So, Marina, back to you. And thank you for reminding us, Irena, that there is more to data protection than, let's say, just digital rule book. There is also the whole area of access to data for law enforcement and other interplays here. So the LIBE committee also does not only act as a co-legislator, but also has the important task of holding the EU executive agencies and also the EDPS as the EU DPA to account. What will be your priorities in this regard, in this mandate? And of course, any other reaction that you have to previous points.
Yes, thank you. One of the first lessons I learned as a diplomat: listen to the question, but say what you find important to say. So, but I'll answer a question. Yes, I think that it will be important that European Parliament and LIBE in particular will continue the work. You know our tools. We have written questions, we have discussions, we have hearings, we have plenary discussions. And I would say that the last week's plenary and the DSA showed very clearly that we will not shy away. And I think we have already sent almost 10 letters, written questions to the Commission concerning digital topics. So we are already in action. I felt very guilty when Alberto was speaking, because as a co-legislator, we're also guilty in the EU legislation being so clumsy and so unreadable. I'm a lawyer and I need lawyers to understand what we regulate. And the whole process for me is completely weird. If you have followed how the amendments are being formed, you just put additional information into paras, into sub-paras, so that in the end, and then you go to the plenary and you vote. Many times I don't know what I'm voting for. Because if you amend this one, it will amend the second one, it will amend the third one, and it's a complete mess. So yes, 100% agree. We need deregulation, and coming from a very small member state, we need less institutions and authorities. We have to be very careful whenever we start a new, establish any new institution. And my final remark will be also on the child sexual abuse material that John mentioned and Irena also said. I think it's a good example of how we have the same goal and we have the same aim, and still it's not easy to agree on the substance. As you know, at the moment there is an interim provisions in force. They will expire in 2026, so we still have some time to negotiate. But here the position of the Parliament and the position of the Commission, and I would say Council, are very different. We put children's rights as a priority, no question about that. No question about that child sexual abuse should be stopped, should be prevented, should be punished, no question about that. But the question is how far we go with monitoring, how far we go with detecting, reporting, and where is the right balance between protection and child rights protection and data protection. So maybe that's just an example how complicated the subjects might be, even when we have the same aim and the same goal. And also, thank you.
Thank you very much, Marina, and thank you all our speakers for all the insights that you have shared with us today. There is no way it can be quickly and briefly, efficiently summarized. So I think it's enough to say that it is a very complex regulatory landscape full of challenges. But there is, to me, a surprising convergence of vision and diagnosis as to what these challenges are, and at least some means to address them in the short term, waiting for further initiatives that would help us all out in the longer term. So with that, I would like to ask you to join me in thanking our panelists. I'm afraid there will not be a Q&A session right now. But we will move immediately to the next point of the agenda. Thank you all very much.